Hello and welcome to Legally Speaking with me, Tarun Nangia. Today, we're going to discuss the issue of possession of assets under the Prevention of Money Laundering Act. Now, this is very important from the point of view of promoters' knowledge. A lot of promoters are not aware what is the process of attachment, when are assets liable to be attached, why is there so much of confusion on this issue. We have some people with us today, two lawyers who deal with these issues day to day. They will clear the air on this issue as well as they will explain what are the rights of the promoters, of the businessmen whose assets are to be attached, what can be attached, what can't be attached, and when possession is taken, what is the point from where attachment goes into possession. They will explain. We will focus largely on the possession aspect because that is what concerns most promoters, because whatever it is, if it's a company or if they are shares, all of that have implications for the promoter. I have with me somebody who knows this issue well. Let me introduce you to Advocate Ayush Jindal. He practices at the Delhi High Court and other forums across Delhi, various other courts, district courts, and also takes up a lot of financial crime matters. Good to see you, Ayush, and looking forward to some interesting insights from you. I have with me Advocate Ansh Singh Luthra. He is a criminal advocate, also focuses on financial crimes, practices at the Delhi High Court and other forums in Delhi. Ansh, you've seen him earlier on the show, articulating on a different topic. Good to see you, Ansh, again, and looking for some good insights from you today. At the outset, may I request Advocate Ayush Jindal that in the first 3 to 4 minutes, if you could lay the ground for the topic and clear the air about what is possession under PMLA, which section, what leads to possession, so that we can begin with our first round of questions. Over to you, Ayush, for your opening comment.
Thank you, Tarun. So, Tarun, may I start with the fact the possession notice that comes under section 8(4) after the confirmation of the attachment is an absurd provision. If I may use this word. I was recently reading an article titled Fading Contours of Presumption of Innocence. This provision in itself is one such example whereby presumption of innocence is being disrespected. And that is a rudimentary principle in criminal law. Let me begin with what is the idea of attachment. The attachment under section 5 of PMLA happens only to safeguard the ED from concealment, transferring, or dealing with the property which is in the ED officer's mind a proceed of crime or emanating from proceed of crime. The possession notice comes after the attachment's confirmation under 8(4). This is a provision which is like putting a cart before the horse. It has not yet been determined whether this is a proceed of crime or this property is emanating from the proceed of crime, which will only be done in the criminal court, in the ED court, special court. Yet they send me a notice, one-line order, saying please vacate it after the confirmation. And therefore, this provision does not pass the test of proportionality. There is an irreversible damage that is being caused to me. A civil consequence, which is dependent on the criminal prosecution, is being conducted before the criminal prosecution reaches its finality. Although the PMLA provides for a confiscation order after the finishing of the trial, after the completion of the trial. And this provides for layers of protection. The PMLA Act in itself and Vijay Madan Lal along with it provides for layers of protection before this property should be taken away from me, because I have a statutory appeal pending. I have the predicate offense, which will go through a complete trial, and I have to be convicted therein. Then there has to be a conviction in the ED trial, and only then this property will be called a proceed of crime. If I am vindicated either of the two, predicate offense or the ED offense, this property will not be proceed of crime. Because as you're aware, predicate offense goes, everything goes.
That's well explained, Ayush. We will come back to you for more detailed questions on this issue. I'll go to Advocate Ansh Singh Luthra for his opening comment on the issue of possession of assets under the Prevention of Money Laundering.
Thank you, Tarun. So the PMLA, I'll start with saying that the PMLA focuses on identifying proceeds of crime, which is in layman's term, any movable or removable property generated out of a criminal activity, whether it is the actual property or value thereof. And it is important that this proceed of crime is derived out of a criminal activity related to the scheduled offense. So what can be attached is the proceed of crime. Now, the next question is whether anything and everything can be attached. The simple answer to that is no. There is supposed to be a nexus between the scheduled offense, the criminal activity, and what is supposed to be attached. So in Seema Garg versus ED, Punjab and Haryana High Court stated that this nexus has to be real and cogent, and this the provisional attachment order therein was quashed, and that was upheld by the Honorable Supreme Court. Justice Lalit wrote that decision. So what has, for example, let's say 90, and the scheduled offense takes place in 2010. So there is no real nexus between the acquisition of the property in 1990 versus the scheduled offense taking place in 2010. And unless that real nexus is there, such property cannot be attached. Now it is also tried law after the Supreme Court has upheld it. And Ayush rightly pointed the PMLA, whether it is under Section 5, Section 8, Section 26, where the appeal lies, or when you go to the High Court under 42. However, there are also certain demerits. So I would try and take you through all of those, starting with Section 5, which is the provisional attachment order. Any provisional attachment order, when passed by a director or any other officer so empowered, can, number one, only be for a maximum of 180 days. Second, it has to be based on cogent reasons, which have to be recorded in writing. It has to be based on material before the said officer. It cannot be in the air. And once it is confirmed, it has to be sent to the adjudicating authority within a 30-day period. So there are all these safeguards in Section 5 itself. And reason to believe is different from a mere opinion, which is also held by Radhakrishnan versus State of Himachal Pradesh. When you come to Section 8, which Ayush was talking about, 8.4, again, there are further, and this adjudicating authority is separate from the criminal court where the trial is taking place. Here, it is dealing with whether there is a reason to believe that money laundering has taken place or somebody is in possession of a proceed of crime. Then they are given notice for 30 days to show cause as to how you earned this money and acquired the said tainted asset. After that, an order of confirmation of the attachment is passed, or the attachment is not upheld. Again, there's another safeguard that it can only be for 365 days or till the end of a trial. Now, there are certain demerits when we come to these provisions and the trials. If, for example, an attachment is confirmed, the trials do take years and years, and till the time a trial is completed, either resulting in an acquittal or a conviction, the said property will remain attached. Though you may be allowed to enjoy the property and stay in the said property, let's say it's a residential premises, however, it will stay attached. And unless you receive a relief in the above system. Second thing, when it comes to bank accounts, for example, once bank accounts are frozen, sometimes accused is even limited in being represented before the court, because he cannot take out any money for his reasonable living expenses or for legal representation. So there is a tough balance that is to be struck between state interest of ensuring that proceeds of crime do not escape and the rights of affected persons. If I may add, in the UK, there are certain reasonable exceptions. For example, Section 303 of the UK Proceeds of Crime Act says that when accounts are frozen, for example, reasonable living expenses, of course, on a case-to-case basis, can be allowed to be taken out, and B, payment of legal fees so that you get appropriate representation in court can also be allowed to be taken out on a case-to-case basis.
Point very well taken. Thanks for taking us through those points on this issue. I'll take this issue now to Ayush Jindal. Ayush, two things. Could you go on to highlight some judgments that speak about possession of assets? What have they clarified to us? And is there anything to learn for other people from it, businessmen who are being prosecuted? What is the view of the courts via various orders and judgments on possession of assets?
So Tarun, the first and landmark judgment on this is Vijay Madan Lal, which although was held 45 to be valid, they said two things in favor of the accused. One is if the predicate offense goes, everything goes. And the second is on this topic of possession on section 8.4. And they said it should be only done in exceptional cases. They use the term exceptional cases. Although that exceptional case is to be determined by the ED officer, we'll come to that later. But Vijay Madan Lal said exceptional cases. Then came Ganpati Dealcom, which relied upon Vijay Madan Lal, said that this provision has the scope of arbitrary application and gave three examples of what could possibly be the exceptional cases. One was the terms used were drug cartel, terrorist activity, and other organized activities, organized crime. So therefore, the Supreme Court went onto an extreme, and these, mind you, these are both three-member bench. They went on to extreme to say drug cartel, terrorist activity, and organized crime. A businessman today, imagine the anxiety. A one-line order comes from the ED officer who thinks any case according to him is an exceptional case to vacate my premises within 10 days of his notice. So I have to go through the rigmarole of challenging this notice, and I have to find an alternative house.
Yes.
So my anxiety with my family is so high at this point of time. There is a clear deprivation of my livelihood, violation of my 21. As I earlier said, no presumption of innocence, not respected. My 300A constitutional right, not respected. I'll give you an example. During the vacations, when the appellate authority, which is only one in all of India,
Yes.
was also on vacation, we received a notice, possession notice for a client. And we had to go in the High Court during vacation to seek a stay of this possession notice on the ground of this. And
Was it the house? What's the house?
It was a factory. All the rules for factory apply differently, and we will come to the rules. But it was a factory. It was a manufacturing unit. But we had to seek a stay, and we got the stay successfully from the High Court of Delhi during the vacation. But when the appellate authority is on leave, they send you a notice, a one-line order to decide. So this is something which is very against a businessman. This is very, very arbitrary.
Okay, point very well taken. I understood what you meant to say. I'll go to Ansh Singh Luthra for his comment on this issue. What are you feeling? How the courts are looking at this? Any orders that you would like to highlight, or any comment on what Ayush said?
Ayush rightly pointed out Vijay Madan Lal and stated that the court made a remark saying that it should be only done in exceptional cases. And Ganpati Dealcom, which says that this provision itself is prone to arbitrary application, because before conclusion of a trial, attachment and confiscation, you are basically taking away the right to property of somebody before even the trial is concluded.
Yes,
that is absolutely correct. In other judgments such as Jagriti, publication, etc., however, another small safeguard is there that the value of attached property cannot be more than a proceed of crime. For example, let's say the ED, again, this could be arbitrary because right now the trial is not completed. Only at a preliminary stage, a value of proceed of crime is determined. So let's say that the ED officer says that the proceed of crime according to him is 10 crores. However, so therefore he cannot attach any movable or immovable property more than 10 crores. So somebody who has an asset base of higher than that with multiple assets would be safeguarded. However, this is like Ayush rightly pointed out, this is still prone to arbitrary application. And in Ganpati Dealcom, the Honorable then Chief Justice of India, Justice Ramanna, refrained from taking this further and stated that this should be dealt with by an appropriate bench. So either there are creases that remain and they need to be ironed out. So either they could be done through a legislative amendment, which would either clarify how attachment is to be done and only certain parts of the law be addressed through that, or the Supreme Court lay down the contours of this law and pass certain guidelines so that businessmen are adequately safeguarded.
So you're looking forward to the Supreme Court guidelines on this issue?
There is a need to either get legislative amendments or the Supreme Court enumerate on this issue, because this is a critical issue which is affecting people even before the culmination of trial.
Point well taken. I'll take this to Ayush Jindal. Advocate Ayush Jindal, two things. The ED officer has a free will to take possession of any property. Can you see? I'll tell you. If you explain me the practical application of this law, not what is written, say, in the book, but do we really see that the officer has a free will to go and take possession whenever a case is filed? Because here, people who watch you will be promoters who want to know in practicality what happens. Can you share with us?
So Tarun, generally what we've seen in the past while dealing with all these cases is the ED officer decides in his own whims and fancies. Because he is an ED officer, he has the power. Once the attachment is confirmed, and in most cases that we see, attachments are confirmed by the adjudicating authority, by a very efficient man, Vinodan. And he serves the notice for you to vacate in his own whims and fancies. There's no law that prevents him from not doing so after these two judgments, although they have said exceptional cases. But that exceptional case is also to be determined which will fall in what category. So for today, for example, I'll give you there's a dichotomy within the rules, is that if your property is leased out, which is a proceed of crime according to the ED officer, and is leased out through a registered deed under Section 17, they will only take away the rent of that property in demand draft as per the rules. But if it is leased out and the will is not registered and exempted under Section 17 of Registration Act, they will ask the leaseholder to vacate. So there is a dichotomy within the rules. Although the law permits me to not register the will, the lease deed, the ED officer will say no, vacate. So there is no set straitjacket formula that we can put into for the ED officer discretion in this.
So you mean all of this gets challenged routinely whenever this happens?
We've done in multiple cases, and we've also been very successful in getting the stay in.
Do the courts give a patient hearing for such issues?
Yes, we have, because then they go, like I said, it's a statutory appeal and in the appellate authority. So it's out to be heard. And we've been successful in securing some release in this.
Advocate Ansh Singh Luthra, your experience on these issues?
So in certain issues, even for example, where a factory is a going concern, let's talk about a factory which is a going concern. The rules permit the ED to direct that any gross income of that factory has to be deposited in the bank account of the Directorate of Enforcement. And that poses a real challenge to a going concern, whether it is to pay dues of laborers or any other statutory dues, etc. However, Ayush is rightly pointing out, generally a patient hearing is given and stay is granted. However, even the FATF, let me point this out to you, even the FATF, which is the world watchdog for money laundering, states that bona fide interests of third parties need to be protected. So when Ayush pointed out the case of a tenant being evicted, that also has to be incorporated in our rules and in our statute, because the Prevention of Money Laundering Act is also a result of commitment to the FATF. It is an evolving and dynamic statute, and like I said, creases remain which need to be ironed out either by the judiciary or by legislative amendments.
Okay, point well taken, Ansh. I'll take this to Ayush Jindal. Very quickly, if you could explain the procedure that the enforcement directorate officer adopts in case of a movable property. We recently saw some high profile accused being arrested, and the value of cars they had ran into well over, say, 100 crore. Multiple cars whose value when they would have been bought would be that much. So it is a big tangible asset in that sense. It's not some small asset, it has a value. Second, what about the immovable asset? Third, one issue which a lot of people are interested in, many times movable assets like cars, when they are impounded, they land up in a condition where they can never be used in future. So does the agency protect, or they languish in bad state? Your inputs on these two issues.
So on movable and immovable, the rules prescribe two different methods. For the movable, for instance, you said the cars. The rules prescribe that the ED officer can get the valuation done from a motoring authority and either get an FD amount equivalent to the value of the cars that has been determined in the valuation report, or sell them and secure that amount.
Oh, he can sell and secure the amount.
He can sell and secure that amount after the valuation from the motoring authority. And for immovable property, they have to maintain, they have to pay the maintenance. And it's in fact a loss to the exchequer if they take possession. For example, in one of the attachments and possession notices after that, ED opened its office in Bombay in a office space that was attached and possession was confirmed. So ED in itself, in order to maintain its office, they...
No, but is it true that it still continues or no?
It still continues, it's still there, and they have a very prestigious address in Bombay.
Okay. Okay, that's an interesting insight. Thank you, Ayush, for sharing this. I think a lot of people wouldn't know this.
That is in fact in one of the properties near Khan Market in Delhi also. It is not just in Bombay. A very massive property near Khan Market is also under the possession.
That's also a possessed property being used.
It's also an attached property. I don't know for what purpose they use it, but I mean, officers are there and certain training purposes, etc., being conducted there.
Point well taken. Your answer, Ansh, on this issue.
So Ayush rightly pointed out how cars are dealt with and how valuation and auction takes place, and in respect of immovable property also. The problem with attaching these properties and taking care of these properties is, it is an additional burden on the state exchequer, whether it is through valuing of movable property and then going through an auction process, or through making an administrator, appointing an administrator who's taking care of immovable property, whether it is a house or a factory, etc. So this additional burden is lying on the state exchequer, and it is at a stage where proceeds of crime is not established. It is only established after the trial is concluded, or, for example, if the scheduled offense goes away, it is quashed, or there's an acquittal in the scheduled offense, all of these attachments will fall. So it is an additional burden, whether it is respect to movable property or with respect to immovable property, which the state exchequer is bearing only to secure the state interest of a potential money laundered, tainted property not escaping that clause.
And you're saying it ceases to exist if the predicate offense lapses?
Of course, because if the predicate offense falls, Vijay Madan Lal clearly states, whether it is an acquittal or a quashing or So therefore, there cannot be any money laundering when there is no scheduled offense. If, for example, no cheating has happened, there cannot be any money laundering or any tainted money out of the alleged offense. When the offense goes away, money laundering goes away.
Point away. Now we're almost out of time, so we will move to a round of closing comments. Advocate Ayush Jindal, your closing comment on today's episode.
I will only say that this provision needs to be struck down. It is not proportional. It causes irreversible damage. And it is also not in the interest of the businessmen and the community and the state in itself, because they are also incurring costs to maintain such properties. So therefore, until there's a final trial, when there is a provision for confiscation, there should be a final confiscation and not an interim possession.
Point well taken, Ayush. I'll go take this to Ansing Luthra for his closing comment.
The safeguards on attachment and possession aren't very robust and clearly have demerits, such as trials taking time and freezing of bank accounts leading to a lot of damage, whether it is to the affected person or people employed by him. So there is definitely a need to strike balance between state interest and rights of affected person, but there is also a need for exclusions to provide for money being used during trial for either reasonable living purposes or for meeting legal expenses, because ultimately you have to give the accused a right to a fair trial, which will incur legal representation before the courts of law, and this can only be done either through a legislative amendment or through guidelines by the Honorable Supreme Court of India.
Thank you for that input. So today was an insightful episode. We got to know many aspects of how ED takes possession of assets, what are the court orders, what are the remedies that clients have, how clients have sought and got relief from the courts in this regard, be it taking possession of a bungalow or a movable asset or a factory, as Ayush explained. We will revisit this issue about 6 weeks from now. Of course, the review petition in PMLA, we are yet not clear whether it will address this issue also. But that case is yet to come up before the Supreme Court. But we will revisit this issue in a month's time. But I highly appreciate we had Advocate Ayush Jindal, Advocate Singh Rutla. You both joined us. You shared all these views with the viewers. I appreciate that you joined. Thank you so very much. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.